Yes, Mr. City.
Their place, Lordship.
Yes.
Item 38. This has been fixed for hearing. At 1 p.m. today, the executive meeting of the bar will be held. So, this matter may be passed over for the day. Let it be taken up tomorrow.
38. Mr. Joshua, you're for the other side?
President and the secretary is the petitioner and the respondent.
Okay. On the prayer of the learned counsel for the parties, pass over for the day. Yes.
Please, Your Lordship.
Yes,
Making a prayer on behalf of Tiba, Your Lordship.
Yes.
Item 47, 50, and 55.
One by one.
Oh, Your Lordship. 50. Item 47.
Ms. Inaoli makes a mention on behalf of Mr. E. Chibapong and seeks adjournment of the case for
After 2 weeks, Your Lordship.
2 weeks. Prayer is allowed, listed accordingly. Then which item?
Item 50, Your Lordship.
Item 50, same? Item
Yes,
50,
Your Lordship.
same, yes. Then,
And 55.
and 55. Same order. Yes.
Much obliged, Your Lordship. Your Lordship, I am also making a prayer on behalf of Vijimo, Your Lordship.
Yes.
Item 48.
48.
After a week, Your Lordship. This may be listed after a week, Your Lordship.
Here on behalf of Vijmo, okay, same order.
And
After a
your-
week, after a
yes.
week.
Your Lordship. Item 51 and 54, Your Lordship. This may be,
On behalf of?
Your Lordship, this matter was previously handled by Supong, Your Lordship, so there's some arrangement going on. So item 51 and 54, Your Lordship.
Okay,
This may be
51,
listed
54.
after
On the prayer of the learned government advocate, listed after
3 weeks, Your
2 weeks, 2 weeks, okay. 51, 54, okay, man.
Lordship. Much obliged, Your Lordship.
Yes, yes.
Yes, my lord.
Yes, please.
Lordship, I may be allowed to make an unlisted motion for anticipatory bail.
What is the urgency?
Direction for arrest warrant has already been issued, my lord, to me, and it is a bailable offence.
It's a bailable offense.
Yes.
Where is the question of granting anticipatory bail?
No, my lord, non-bailable warrant of arrest,
None.
direction has been issued, lordship.
Okay, let us,
Oblige, my lord.
yes.
May I please, Your Lordship?
Uh,
Can I make a prayer for unlisted motion, my lord?
What is the urgency?
Criminal petition, my lord.
No, list it tomorrow.
My lord.
Okay.
Please, lordship.
Yes, please.
Lordship, I beg to mention hearing item number 40. Lordship, let the matter come after 2 weeks.
Why?
Lordship, my senior here has some personal difficulties to take up the matter.
Mr. Sensor makes a mention on behalf of, who is your senior?
Sir Mohad Jamir.
Makes a mention on behalf of Mr. Moa Jamir, the learned counsel for the petitioner, and seeks adjournment of the case after a week. Prayer is allowed, listed accordingly. Okay.
Deeply obliged.
May I please, Your Lordship?
Yes, please.
Lordship, I beg to mention item number 43, Your Lordship, for hearing.
Yes.
Lordship, I pray that the matter be posted for 30th of September, Your Lordship.
For?
Hearing, Your Lordship.
For?
For the appellant, Your Lordship.
No. Which date?
12/09/2023, Your Lordship. Next month, Your Lordship.
On the prayer of Mr. M. Solo, the learned counsel for the petitioner, learned counsel for the appellant, correct?
Lordship.
Listed on 12/9/2023. Okay. Yes.
May I please, Your Lordship?
Yes, please.
Lordship, I would like to mention item number 42, hearing.
Ah,
Lordship, this matter may be come up on 12th of September, Lordship.
why 12? Is it an auspicious day?
No, Your Lordship.
You're the counsel for the,
Lordship, for
Respondent.
the sole respondent.
for the sole respondent. On the prayer of Mr. So-and-so, learned counsel for the sole respondent, listed on 12/9/2023.
Obliged, Your Lordship.
Yes.
Yeah, please, Your Lordship.
Yes, ma'am.
Your Lordship, I beg to mention for item number 6. Uh, Lordship, on behalf of.
Let it come as per the list. Let it come as per the list.
Yeah, please, Lordship.
Yes.
Lordship, I beg to mention item 53 hearing.
Yes,
I am for the petitioner in this petition, Lordship.
yes,
Lordship, I have some personal difficulties today.
okay.
So, matter listed on Thursday.
Not on Thursday. You take next Monday.
On Tuesday,
This Tuesday?
next Tuesday.
Next Tuesday, okay. On the prayer of Mr. Oti Jamir, the learned counsel for the petitioner, listed on,
Fifth,
yes, 5/9/2023, okay.
Okay.
Now, please.
Yes, yes,
Now, please to mention item number 49, Your Lordship.
49.
Lordship, let the matter come up after 3 weeks, Your Lordship.
Therefore,
For responding, Your Lordship, actually, this matter relates to minimum scale of pay, and we have already filed an SLP, Your Lordship, but I need to get the SLP number, Your Lordship.
okay. On the prayer of MS Livika, the learned government advocate, listed again after 2 weeks. Okay, ma'am?
Lordship.
May I please, Your Lordship?
Yes,
I
please.
beg to mention hearing item number 52, my lord. I would like to withdraw this petition, Your Lordship, as I have an instruction to withdraw, Your Lordship. So,
MS so learned counsel for the petitioner,
yes, Your Lordship, and for the petition.
submits that she has instructions to withdraw the writ petition. That is allowed? Writ petition is allowed to be withdrawn. Okay.
With the liberty to file afresh, ma'am.
With liberty to file afresh. Okay.
Much obliged, ma'am.
Call this one.
May I please, my lord, my lord, my lord.
Yes, please, Mr.
Item number 39, Lordship. Lordship, you may be released after 1 week, Lordship. 39.
Let it come as per the list, let us see. Okay?
Lordship.
For motion, item number 1.
May it please, Your Lordship.
Yes.
Your Lordship, this is a revision petition impugning the order dated 14/7/2023 passed by the Learned Civil Judge Senior Division Dimapur,
Yes, yes.
rejecting the plaint, Your Lordship.
On
Now, Your
what
Lordship,
ground? On what ground?
there is no ground. It is in her observation, the Learned Court is telling that there is no cause of action. Again, when the order came, then we find that under order rule 11D, that it is barred by any other law. There is no semblance or there is no finding, there is nothing in this order, Your Lordship. Your Lordship, the fact of the case is that I am a building owner. In 2017, Your Lordship, I am having my building in Bamakem. In 2017 on Dena Bank. Dena Bank has approached me and requested me that you are having a building, so why don't you offer it to for our bank? Then, Your Lordship, in 2017, I just, according to their requirements, I made the building internal change, and I entered into a lease deed with them in 2017 for a period of 15 years for running their bank. Then, Your Lordship, they entered into bank building, and they have put up their vault. That time also I have entailed huge amount for reconstruction of the building. Now, after 3 years, Dena Bank amalgamated with Bank of Baroda. Then in 2019, there is section 2G of the, article 2G of the lease deed, Your Lordship. There is a provision that lessee can come out or terminate the lease deed at any point of time. So, I am not on that, Your Lordship. Now, what happened, Your Lordship? After the termination of the lease deed, although I paid, there was an ATM also. Then I told them, okay, at least you take back your properties and all this. So they are not giving any proper reply and killing the time like that. Now, you see, finally what happened, after 2 years, while I sent the notice that you, since you are in occupation of my building after termination of the lease deed, then you are entitled for rent to pay me the rent because my building has otherwise been blocked by you. You have not removed your property from there. Then your lordship, they gave a reply. Then I went to court. Now, court is having impression that there is no cause of action as defense taken by defendant. But position of law is very much clear, your lordship. There are pattern of judgment of the Honorable Apex Court where it is said that this cause of action, this is the entire discussion of the Honorable Court taking over the matter after examining the bundle of facts to determine that whether there is any cause of action. Now, there is a lot of bundle of facts I have narrated before the Honorable Court. Furthermore, in para 14 of my plaint, I have categorically stated that cause of action in the suit arose on such and such date. Then, when the lease deed was terminated, then I gave my correspondence with the vendor, then they replied. Then, these cause of action categorically I have stated in my plaint, your lordship, in para number 14. But I do not know if your lordship kindly go for the order, then your lordship will find that the learned court below has referred on Supreme Court judgment, where the learned court is telling that one defense cannot be.
If the suit was dismissed on the ground of preliminary objections raised.
Yes, your lordship. Now-
Mr. P.B. Paul, the learned counsel for the petitioner. Stop. The petitioner, as the plaintiff, has filed. What is your civil suit number?
4/22, your lordship.
Has filed civil suit number.
That is page 14, your lordship.
Just wait. Has filed civil suit number 4/2022. Seeking recovery of errors of rent. Errors of rent. The stop. Respondents/defendants in the case has filed the written statement wherein preliminary objections were also raised on the maintainability of the suit. The learned the learned civil judge, Senior Division, Dimapur, Nagaland, after hearing the parties on the maintainability of the suit, has passed the order dated 14/7/2023. Rejecting the plaint under Order 7, Rule 11, Clause D of the Code of the Civil Procedure Code, observing that there is no cause of action. Being aggrieved, stop. Being aggrieved, by the order dated 14/7/2023. The petitioner has filed the present petition. Stop. Issue notice to the respondent. Returnable within 4 weeks. Stop. The learned counsel for the petitioner shall take steps for service of notice upon the respondent by registered post with AD as well as by dusty process.
Yes.
Dusty process within a period of
3 days.
within a period of 3 days from today. Stop. In the interim, it is ordered that the order dated 14/7/2023 passed by the learned Civil Judge Senior Division, Dimapur, Nagaland, in civil suit number 4/22 shall remain suspended till further orders. Stop. Stop. Registry to call for the records from the court below. Okay.
For motion, item number 2.
Yes.
Well, please, Your Lordship. Your Lordship, here the petitioner is approaching this honorable court for praying for latest revision of PSKO, Your Lordship.
What is the nature of your appointment?
Your Lordship, may kindly see my annexure 2 at page 13, Your Lordship.
Correct.
Your Lordship, here after the petitioner was appointed, his post was extended in the scale pay of rupees means so, Your Lordship. However, till that his scale of pay was given at the ROP 1983, Your Lordship.
But Mr. So-and-so, the learned counsel for the petitioner. Stop. The petitioner was initially appointed to grade 4 to a grade 4 post on contingency basis in a fixed pay of rupees 1,500 per month. By the order dated 31/1/2007. Stop. Thereafter, the petitioner was appointed to the post of peon on ad hoc basis in a scale of pay in the establishment of the Chief Medical Officer, Kipiri. The grievance of the petitioner is that he has been paid scale of pay in terms of the ROP 1993, whereas similarly circumstanced employees have been extended the latest ROP as applicable to the state government employees. Stop. The petitioner has submitted representation requesting the government to pay him the latest ROP. However, his representations has failed to evoke any response from the government. Stop. Being aggrieved, the petitioner is before this court. Issue notice to the respondents, returnable within 4 weeks. Who is appearing for the government? Since M.S. Mary, the learned senior government advocate, appears on behalf of the state respondents, no formal notice need be issued. Stop. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned state council within a period of 2 days from today. Listed after, listed accordingly.
For motion, item number 15.6, supplementary costs.
What is this case about?
Your Lordship, the land in question is village land of Purana Bazar B. The appellants, this is an appeal against the ad interim injunction order passed in I-8 29, Lordship, I-8 29 of 2021 before the principal district judge, Dimapur.
will issue notice.
Your Lordship, the interim, the order may be suspended, Your
Who
Lordship.
is for the other side?
I filed a caveat, Your Lordship, but it
Yes.
has not been reflected.
It is reflected in the.
Now, Your Lordship, this petition is, this revision is, appeal has been filed under Order 43, Rule 1R. Read section 104 of CPC. Order 43 is pertaining to injunction. We are challenging the injunction order. But nowhere this petitioner has said in what manner the order passed by the learned court below is illegal, arbitrary, or without application of mind. Nowhere it is said. Their main position is only this factum of that how the land came, it is a land of such and such and such. Your Lordship, Order 39, Rule 1, injunction, it is section 151. The court has to take golden principle. Number one, whether there is a prima facie case. Number two, whether balance of convenience and whether irreparable loss is suffered. Now, Your Lordship, taking into consideration all these three aspects, it is not a cryptic order, it is a speaking order, and all the this Draupad Kumar, the famous case of Draupad Kumar, that was referred.
Who is in physical possession of?
I am in the physical possession, Your Lordship.
Right now, they have occupied on the basis of this. They are
And now I
now,
am in the physical
they
possession.
are now developing the land with hundreds of laborers, Your Lordship, on the basis of this, Your Lordship. And at interim injunction, it ought to be, as per settled law, it ought to be only status quo order. But the order is so perverse that it amounts to, the order itself amounts to disposal of the main suit, Your Lordship. It is not-
Mr.
the action has been-
Tongpok, Ponganer, the learned counsel for the petitioner. The learned counsel for the appellant. Stop. The present appeal has been filed under Order 43, Rule 1, small r clause, within bracket R, Rule 1R, read with Section 104 of the Civil Procedure Code 1908 against the impugned order dated 28/7/2023, passed by the learned Principal District Judge Dimapur in
IS bill number
IAS Civil Number
29.
29/2021. Whether state is a party?
State has been
Yes.
met for former respondents in the IA, Your Lordship. So, state is a party.
Since, stop, Mr. P.P. Paul represents. Mr. P.P. Paul, the learned counsel for the learned counsel represents the private respondent number
One,
One
112.
One only.
Oh,
only one.
And the others are.
no. Since Mr. P, you please cancel that. Since you cancel the word, since Mr. P. Paul represents the respondent number 1, and who's for the government?
Lordship, we have not been served a copy.
No, we have.
Anyway, Lordship, I will-
And Mr. N. Angami, the learned senior government advocate, appears on behalf of the state respondent number
3, 4, 5, and 6, my lord.
3, 4, 5, and 6. Stop. No formal notice. Therefore, needs to be issued to the said respondents. The learned counsel for the appellant shall, however, serve requisite copies of the appeal petition to the learned counsel for the respondent number 1, as well as the learned senior government advocate within a period of,
Within the week.
within a
Within
period,
this week.
within a period of 7 days from today. Insofar as the respondent number 2,
Only 2. Respondent number 1, myself, 2 is pro forma respondent 2, village council Purnawati.
have you seen the petition, Mr. Paul? 2, 3, 4, 5, 6, 7, 8.
Oh, this is the petitioners, Your Lordship.
Oh,
There are more than 70.
okay. Okay,
50,
okay.
Or 69
Okay,
petitions.
okay. So insofar, please cancel that. Release the keys after 4 weeks.
My lord, I had a caveat also.
In the interim, the parties shall maintain status quo on the land/property covered by DAG number 104
104, Your Lordship.
at Purana Bazar village till the next returnable deed. The caveat accordingly stands discharged.
Right.
My lord, I have a prayer hearing that page 63, annexure 1 cannot be, it is not readable, Your Lordship, anything I cannot understand. Page
That
63.
copy is there. That copy is there.
First page. This is the type of your lord.
Is it available? Type copy?
Yes, Your Lordship, it is,
Letter regarding, this is the.
oh, I will provide him with a type copy, Your Lordship. It is.
List of
this is the
village,
one, this is the one.
list of village towns.
What is that page? Page 63.
71 is the type of, yes, Your Lordship.
71 is the type copy.
Because,
Type copy is there.
yes, Your Lordship.
I have,
63 is so much eligible, I could not.
type copy is already there. All the clear copies we have provided. Because of this.
71 is the type of,
Okay, okay.
much only.
For admission, item number 3.
Yes. Mr. Joshua,
Yes, Lordship.
what was the instruction sought for? Last time?
Oh, my lord, apologies, my lord. Oh, my lord, the agreement has been executed under the initiative of the state respondents.
What agreement?
The agreement that grade 4 post will be the next year of my petition, Lordship.
Annexure?
Next year, Lordship. This is the agreement. If I may be allowed to read, my lord. Page 14. May I read, your Lordship?
What was the instruction required on this agreement?
Lordship, what instruction is to be required, Lordship? The agreement is that a grade 4 post on the free donation of land by the landowner, the state will accord appointment the grade 4 post to the landowner lordship. This agreement was executed on the first day of March 2011.
Oh, this is that case where you are refusing to accept compensation?
Yes, lordship.
No.
Oh, my lord, apparently the state respondents have been submitting before this honorable court time and again that ADC is not the appropriate authority.
That this is not the appropriate authority and.
Then in that case, lordship, they have been occupying my land illegally for all these years. Just return my land, lordship. If they don't want it, then they have sent an illegal authority to take my land, then.
Mr.
Yes,
Joshua,
lordship.
don't go against the law. If you
No,
want
my
to
lord.
take back your land, be in prison for some days. That is all.
How is that possible?
When actually the land has been used for public interest. How can you say that if public interest, if you are not actually compensated with a grade 4 appointment?
No, my lord.
The government is willing to compensate you for the land.
Lordship, this is a private land. This is not our state's lordship. This is a village area private land. It is on the assurance of the state respondents that grade 4 post will be given, lordship, under the initiative, and if the state is saying that this is not the authority, my lord.
You go in appeal, I am dismissing. Okay, reserved.
Bless you, lordship.
Yes. Next.
All right, mission, item number 4.
Back to the lordship.
Yes.
Lordship, I'm mentioning on behalf of additional 18 song for the state respondent.
But Mr. A. Jimomi,
Yes, my lord.
I think I am disabled from taking this case. Because though my friend Mr. T.B. Jamir, he was taking up the case on behalf of the government,
Yes, yes.
we used to have a constant consultation in the chamber.
That's all right, my lord.
And we have shared inputs on this.
Very well, my lord.
So
Very well, Mr.
it may not be proper for me to take up this case.
Very well.
And even Mr. Azo, I think we had also discussed on this issue.
Oh, okay. Any other mention?
Listed before the appropriate bench without me. Please don't mind. Yes.
All right, mission, item number 6.
Yes.
Lordship, on behalf of my senior AD Lordship.
Ah.
Lordship, he's on his leg in court number 2.
Okay. Code number 2?
Yes.
We have code number 2. Today. Oh, video conference. Okay. After part 1 matter.
Let it come after 2 weeks.
Make a correct submission. Oh. Yes, this is 2016 matter,
Yes.
2017 matter.
I'm ready with the letter. Lordship.
Yes. Where is he?
He's in court number 2. In his leg in court number 2.
Okay, let him finish, let him come. We will hear him. Okay, let him come. This is 2017 matter.
Bless you, lordship.
All right, admission, item number 7.
May I please, Your Lordship? I'm
Yes,
asking
please.
on behalf of Tiba, Your Lordship. This matter may be listed after 2 weeks, Your Lordship.
Yes, Mr. CT.
Gentleman is out on the ground of fever. First father has been expired. Lordship.
Oh, okay. Shall we grant?
Let it be taken up as and when his
Okay. MS Inaholi submits that Mr. E. Tiba Pom, the learned government advocate handling the case, is in bereavement and therefore seeks adjournment for 2 weeks. Prayer is allowed. Listed up to 2 weeks.
For admission, item number 8.
This Your Lordship,
Yes.
I believe this matter may be listed after 2 weeks. Pleadings are completed.
Well, what is the matter, Mr.
Now
Kichu?
that the petitioner is challenging the appointment of the private respondent on the ground that the petitioner's case, online ownership was not considered.
Pleadings completed.
My lord,
It is submitted. Well, listed for hearing.
my lord.
It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be listed for hearing.
Obligement.
Listed for hearing in the usual course, okay?
For admission, item number 9.
Your Lordship,
Yes, please.
and for the petitioner here, I pray that the matter may be come after 2 weeks, Your Lordship.
What is your case?
Your Lordship, the petitioner is seeking for pensioner benefits, Your Lordship.
Pensionary benefits.
Regularization, Your Lordship.
Pardon?
This is for regularization.
Regularization. Give me a minute. Okay. Why not today?
Your Lordship, item number 6 is also to be heard today, Your Lordship. My senior will appearing, so I pray that this matter will come after 2 weeks, Your Lordship.
On the prayer of Mr. Subhamwati Jamir,
Warning, Your Lordship.
sir, I'm sorry, Subhamwati Walling, the learned counsel for the petitioner, list the case after a week. Okay.
Obliged, Your Lordship.
For admission, item number 10 and 11.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention on behalf of our private respondent in Longkoma. Lordship, counsel is in disposal. Kindly list this matter after a week.
Mr. So-and-so makes a mention on behalf of Mr. N. Longkoma, the learned counsel for the respondent number. Respondent number, and
I'm not a sure.
no, respondent number, and Longkoma is for respondent number
So respondent number 4.
for the, Mr. N. Longkoma, the learned counsel for the sole respondent, and seeks adjournment of the case after a week. Prayer is allowed, listed accordingly.
Most likely.
For admission, item number 12.
May I please, Lordship? Lordship, here the service are completed upon respondents and it's ready for hearing. Lordship, may any calls for the records and ready for hearing, Lordship. It's an MCAP.
Record has not been called.
That's why, Lordship, kindly call for the record, Lordship. My submission is that. Call for the records.
Yes, Mr. Chetri,
No objection, Lordship.
call for the records from the court below. List the case after receipt of the records.
Lordship. Obligement.
For admission, item number 13 and 14.
Yes,
Item number 13? No.
13. Item number 13.
what is your IA?
Interim application number 80 of 21.
No, what is your IA? What is it for?
It is for condonation of delay, but it is not required because on the strength of Supreme Court direction.
Yes, Mr. Mitch,
Your Lordship?
do you have any objection?
Yes, I raise objection to the prayer of the applicant for condonation of delay.
What is your
I have
objection?
even filed my written objection.
How many days?
117 days. On the strength of Supreme Court direction, there is no delay. Because Supreme Court,
Where is that Supreme Court's order?
it's my, page number 2, para number 3.
Where is DIA? Okay, okay. When did the delay commenced?
Delay,
Where is that the statement?
it is actually properly explained in IA number 81, appended with MSc page number 10. They are analogous matters. So may I read the,
What is your IAT?
they are similar, but somehow my junior made a mistake and he did not properly explain that those 2 paragraphs were missing in this IA number 80.
Same case.
Same case. 2 paragraphs are missing. So may I be allowed to read those relevant paragraphs
From where?
from my interim application?
Your interim application?
Yes. On page number 4, my interim application, page number 4.
Let me see.
It starts from para number. The appeal is filed 20th July 21. So it is well within limitation.
Can you kindly tell me the period of delay?
Delay is 117 days.
No, and from when the delay commenced?
It was, the award was dated 4/2/21 and limitation
4/2?
2021.
Yes,
And
4/2.
My permitted period was up to 4/5/2021.
Yes.
Memo of appeal was filed on 20 July 21.
21?
20th July 2021. As per Apex Code direction, limitation starts running after 2nd October 2021.
2nd, 10,
October
20,
2021.
21.
Yes.
Up to?
No, this is up to, this is for, yes. Up to 2nd October, it has been waived, that the delay has been waived by the Supreme Court direction. On page number 2, para number 3.
Yes, Mr. Mitch. Have you seen this order passed by the Honorable Supreme Court?
You know which date of the order you want? It is
10 January 2022.
Your Lordship, may I please beg to state that I have mentioned in my objection petition. Which one? At para 6. Para 5. Your Lordship, in terms of this Honorable Supreme Court's order dated 27 April 2021, the appeal filed by the
27 April
2021.
27 for 2021.
Yes.
2021. Why don't you read this 10 January 2022? 10 January 2022. That is the latest order on limitation.
At the time of filing these appeals, there was no coverage of the Honorable Supreme Court.
No.
At the time of filing, the court was in function, Your Lordship.
Appeal was filed on 27/2021.
Yes. So,
The-
during this relevant period,
The period from 15/3/2020 till 28/2/2022 has been excluded for the purpose of limitation. Heard, Mr. So-and-so, MS so-and-so. This will be in miscellaneous IA 80 KV. IA 80 and 81 same.
Same.
Okay, IA 80. Heard, MS so-and-so. The learned counsel for the applicant. You are appearing for all the respondents? For all the respondents?
respondent number 1 in both the cases, claimants.
No, let us come one by one. 80,
80 yes.
1.
1.
Respondent number 1. 2 and 3.
And you'll see, I'm agreeing to respondent number 4 and 5.
4 and 5. Mr. MS so learned counsel for the applicant, and Mr. N. Mitch, the learned counsel for the claimant respondent number 1. Also heard Mr. N. Luikam, the learned counsel for the respondent number 2 and 3, and Mr. P.B. Chetri, the learned counsel for the respondent number 4 and 5. Stop. This application has been filed. You have not even mentioned the section under which this application is filed. Next time, be careful. We will dismiss. Stop. This application has been filed for condoning the delay of 107 days in preferring the appeal against the judgment and award dated 4/2/2021, passed by the learned member, Motor Accident Claims Tribunal, Dimapur, in MSC case number 85/2014. It is submitted by the learned counsel for the applicant that against the award dated 4/2/2021, the present appeal has been filed on 27/2021. Stop. This court has perused the order dated 10/1/2022, passed by the Honorable Supreme Court, in extending the period of limitation during the pandemic. Stop. The order dated 10/1/2022, passed by the Honorable Supreme Court, has ordered that the period from 15/3/2020 till 28/2/2022 shall stand excluded for the purpose of limitation as may be prescribed under any general or special laws in respect of all judicial or quasi-judicial proceedings. In view of the order dated 10/1/2022, passed by the Honorable Supreme Court, this court is of the view that the delay of 117 days falls within the limitation as ordered by the Honorable Supreme Court. In that way of the matter, the delay of 117 days in preferring the connected appeal is condoned.
Your Lordship,
The application accordingly stands disposed.
Your Lordship, in the meantime, the appellant may be directed to deposit the 50% of the awarded amount.
We have not admitted the appeal, just wait. The same order will be passed. In this, no, not done, right? Same order in 81, okay? In the main appeal, which are the main appeal?
9 and
9
10
and 10.
of 2021.
There is no application for staying,
No.
then you deposit the full amount.
Lordship, full amount, so it will be a
Arre,
injustice to me.
It is not injustice.
At least 50% may be allowed.
You have not even actually like discharged your responsibility of filing a stay.
In my main application, I have written to stay.
No.
But no separate petition has been filed.
You know the law.
So, usual thing maybe we have deposited.
You come up with that.
50% may be
appeal admitted?
Lordship, 50% may be allowed to be deposited. 100% because I am on quantum. I am on amount of
Appeal
compensation.
admitted, listed after 3 weeks. In the meantime, you file your application for stay.
Okay.
For admission, item number 15.
May I please, Your Lordship?
Yes.
Lordship, I'd like to mention on behalf of the petitioner, counsel, and Lokum. Lordship, the petitioner counsel is indisposed. Kindly list this matter after a week.
Mr. So-and-so submits that Mr. N. Longkumar, the learned counsel for the petitioner, is indisposed and therefore seeks adjournment of the case after a week. Prayer is allowed, listed after a week.
Much obliged.
For admission, item number 17.
May I please the Lordship?
Yes, please.
Lordship, and for the state respondent Lordship. Lordship, if this matter can come up after 2 weeks, Lordship.
This is civil revision.
Civil revision, Lordship.
Why the state is a party here?
Lordship, in fact, the private respondent.
Who is for the private respondent?
The Lordship private respondent steps is being completed, Your Lordship. They have not appeared, Your Lordship. Court order dated 9/9/2022, Your Lordship.
9/9.
2022. It's been, it states that the steps upon respondent 4 and 5 has been completed, Your Lordship.
Completed?
Yes, Lordship.
Four and five, correct?
Yes, yes, Lordship.
Mr. V. Jimoy, are you also appearing for respondent number 3?
Lordship, 1, 2, and 3, Lordship.
1, 2, and 3. Head Dubashi also. 3 is Head Dubashi.
One and two.
What is the role of the Head Dubashi here?
Your Lordship, I decreed by the order passed by the DC, Your Lordship.
DC?
No, Lordship, head Dubashi, Your Lordship. Dubashi Court's order, Your Lordship. Since the Dubashi Court had passed a judgment, Your Lordship.
So is it necessary to implement the?
Your Lordship, there are some documents which have been forwarded by the head Dubashi also to the Deputy Commissioner. So it has become a necessary part.
And what is the role of the Deputy Commissioner?
Deputy Commissioner have taken a step against the judgment passed by the Dubashi, Your Lordship, directing me to vacate the place, Your Lordship.
Okay, so DC's order is against the judgment passed by Dubashi's court.
No, they have complained that the Dubashi's court's order, Your Lordship, directing me to vacate the place.
So, okay. So, yes.
2 weeks, Lordship.
What is the ground? What is your ground?
Lordship, since on the last occasion, Lordship, this honorable court has directed to take instruction, Lordship, from the Deputy Commissioner, Walker, Lordship. Till such time, Lordship, I have not received.
You have filed your affidavit?
No, Lordship.
Oh, no affidavit has been filed.
Yes,
Okay. Mr. V. Jimami, the learned government advocate, 6 for 2 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 2 weeks, okay?
Your Lordship, interim may continue.
Okay, okay. The interim order passed earlier shall continue till the next returnable date.
No questions.
For Bishop, item number 18.
11:30 जमादार के कुछ बाहर ले जाओ. Yes.
I'm agreeing for respondent number 1 and 3.
Yes, Miss Apila, you are the container.
Lordship, I
You are the
have,
person who has disobeyed this court's order.
Lordship, we have already filed our affidavit as well, which was
Okay.
directed by this honorable court.
Yes.
However, if I may take you to this honorable court to order dated 21/4/2023, Lordship.
Which page? In,
So this is order dated 21/4/2023 of this.
okay.
Order of this.
21/4,
2023.
21/4/20, okay. Yes,
Lordship, in page number 2,
para 2 or page 2?
page number 2, Lordship.
Uh,
Page
the-
number 2, paragraph 1.
This is only one page.
Lordship, Lordship, paragraph 2, Lordship. The submission of this, the submission of the petitioner, Lordship.
Mr.
If I may read.
Tompok,
Mr. Tombok, Commoner, learned counsel for the petitioner, has fairly admitted that as on date, no construction is on. But when this contempt was filed, construction was going on, which compelled the petitioner to file this contempt petition. Accordingly, Lordship, I have filed my affidavit on 2nd of June 2023, Lordship. And I've
Second.
clearly mentioned and put on record the latest progress and the development.
what is your case, ma'am? What is your case?
Your Lordship, the instant petition is filed against the respondent for acting in violation of the order dated.
What is the order? Let us see, what was the order?
2017, Your Lordship.
What was the order? Which page of your petition?
Page 11, Your Lordship.
Page 11. Page 11. So no more contempt, Mr. Tompok. No more contempt.
Your Lordship, content is that they continue to develop the land, construct the building even after the order was passed.
So they have
Only
stopped.
After filing of this petition, they stopped. Only after the contempt petition was filed and notice issued, they stopped. But prior to that, there was an order also of this honorable court earlier, and then the ADC had also issued restraining order in starting from 13th of April 2017. That they had no business to do the construction. When all this restraining order and, sorry, Your Lordship, this honorable court's order was in place. But they have erected all this in violation of this honorable court's earlier order, which is.
Is it a permanent structure?
It's a permanent one. Your Lordship will see the annexure, which is which has been provided in the reply also and in my petition.
Where is that?
Page 21, Your Lordship.
Of your petition?
Yes, in my petition, page 21, Your Lordship.
Page 21.
Yes.
It's a Taj house.
No, the one next to it. These are constructions, ongoing constructions, Your Lordship. They started constructing this in the month of May of 2022, Your Lordship.
Ms. Apila, you instruct your clients to dismantle what has been constructed
Lordship.
in violation of the order.
Lordship, if I may take due to this honorable court to my affidavit file on second.
What do you say? What did you say?
Lordship, I have already took, clearly annexed the present position of the construction, Lordship, that no such construction has been developed nor any development has been taken place. And so, Lordship, as fairly admitted by the petitioner also, no such development is.
Then what about this construction? This was before
This
the...
was long time, that was there prior.
Okay, Mr. Tongpok, let us not go into details since the work has stopped.
Lordship, even the picture says so that even the animals started staying in the construction, Lordship. So no such development, Lordship.
Your Lordship, the matter will be listed together with the main writ petition. So
Okay,
that-
okay, okay. Okay?
Lordship, Lordship.
Okay. List the present contempt petition along with WPC 58K of 2017. We are not passing any order as to when the case will be fixed, okay?
Obliged, Lordship.
Yes, excuse me for 5 minutes.
Item number 19.
Yes,
May it bless your lordship.
yes, Mr. Moore.
Your lordship, I represent Mr. Respondent number one here in this contempt petition.
One.
Lordship, department has taken all the initiatives, but for salary PIMS, personal information management systems, that has to be given only by the BNR. That is why it is pending there in the BNR department. So if my friend agrees, I may be allowed 1 month's time. By that time,
I have no objection.
I'll try to query.
You were supposed to get the, Mr. Santiyama, you were supposed to get the PIMS.
Yes, my lord. My lord.
Are you taking steps?
Yes, my lord. I have
Yours-
submitted a presentation, my lord.
As per his submission, I think the government is willing to help you.
Yes, my lord. My lord. I have no objection to the prayer made by the.
What is your prayer? Your prayer is for,
More time, because BNI was not implemented as a partner respondent in the contact. So, but he has to take initiative.
that's.
This meantime, I may be also allowed to make a representation.
Otherwise, department has already
For the
submitted to the
BNR.
BNI department.
To the PNR?
Yes, my lord.
Okay. Mr. Santiyama, the learned counsel for the petitioner, submits that he may be allowed some time for enabling the petitioner to take steps with the PNR department for availing the PIMS.
My lord.
Okay?
My lord.
3 weeks' time is accordingly granted to the learned counsel for the petitioner to take steps. Stop.
Deeply obliged, my lord.
For admission, item number 2.
May I please, my lord?
Yes.
Lordship, I'm making a mention on behalf of additional GV Chokre.
Okay.
Lordship, I'm told that she is appearing for all the respondents here in this contempt petition.
Okay.
I'm also told that she is here to receive instruction from the department, your lordship, if 3 weeks time.
Okay.
Lordship, can you see the order? The order was passed on 19/5/2022.
What was the order?
Direction was issued to grant minimum pay scale to the petitioner, who is serving for more than 28 years and work charge fixed fee. Now, the contempt petition was filed on 14/10/22, except verbal submission that the authorities are taking steps to consider the case of the petitioner. No record has been produced. What step they have taken to comply with the court's order?
What is
It's more than a year also.
This order 24/3/2022.
Court's order, Lordship?
Yes, yes, at page 15.
Page 19, Lordship.
Page 19.
One nine. Next page is order dated 19/5/22.
19/5/2022.
Yes,
Which order?
court's order, page 20.
Ah,
And the operative part is page 22.
okay.
So, Lordship, my humble prayers direction will be issued to my learned friend,
progress this court, what steps were taken by the authorities to complaints of this order?
On the next date fixed, the learned Additional Advocate General shall place the records of the case which has been taken for complying with the order dated 19/5/2022 passed by this court in WPC 86/2022, listed after 3 weeks.
Okay.
Obliged, Lord. For admission, item number 21.
Yes, Lordship. My lord, I'll be filing my affidavit in reply during the course of the day. So if this matter can be listed after a week.
Okay, okay. Mr. Takakichu, the learned counsel for the petitioner, submits that he will be filing the affidavit in reply on behalf of the petitioner in the course of the day, and therefore seeks for a week's time, listed after a week.
Obliged, my lord.
For admission, item number 22.
May I please, Your Lordship?
Yes.
Lordship, we are expecting the documents from the tribunal Mukuktum. So kindly grant us 4 weeks' time to file affidavit in opposition to the IA filed by the appellant.
You are for the, ma'am, you are for this?
Respondent number 3, honor of the truck.
Honor of the truck. MS Senso, the learned counsel for the respondent number 3, seeks adjournment of the case for 3 weeks.
4 weeks' time, Lordship.
For 3 weeks. Prayer is allowed, listed after 3 weeks.
Not obliged.
For admission, item number 23 and 24.
Yes, Mr. Nanami.
Lordship, in fact, the state has preferred an appeal against the order passed by the learned single judge, and the appeal was allowed. However, on the last occasion, Your Lordship, the petitioner has made a mention that they have filed an SLP before the apex court against the decision passed by the division bench of this honorable court.
May I please, Your Lordship? Your Lordship, we are yet to obtain the SLP number as we are informed by the counsel of the writ appeal that the writ appeal is under scrutiny. So you may kindly allow us 4 weeks' time.
MS Enso, learned counsel for the petitioner, seeks for 3 weeks' time to place on record the informations in regard to the SLP filed before the Honorable Supreme Court, listed after 3 weeks.
Obliged. For admission, item number 25.
Yes.
May it please, Your Lordship.
Lordship, I'm the Kohima respondent 1, Deputy Commissioner Dimapur. But previously, all the land acquisition, compensation, all are processed through the office of the Dimapur DC. But after the bifurcation of the district, all files were transferred to Chumkedima district. So, in that view, in the light of that, Lordship, the DC Chumkedim may have to be impeded as.
Your records are not there in the Dimapur.
My lord. Then I have to file amendment petition again, amending Deputy Commissioner Dimapur to Deputy Commissioner Chumukidima.
That is your lookout.
Actually, they are performer respondent, Your Lordship.
They're just performer.
Performer respondent.
But still then we have to see. We have to see. Because all landed matters and all this, I think DC is, I think, quite important.
This matter is pertaining to that, Your Lordship.
Mr. P.P. Paul, shall take steps
Implement.
for implementing the Deputy Commissioner Chumukidima as the party respondent number,
Pro forma respondent, Your Lordship.
as the party respondent number, pro forma respondent also, as the respondent number.
Respondent number, two.
Who is two now?
Two is an FLA. One is Deputy Commissioner Dimapur.
As the respondent number three. As the respondent number three in the written.
Three.
Listed after 2 weeks. Take steps for implementing.
Bless you, Lordship.
Admission, item number 26.
Please, Your Lordship.
Yes,
Lordship,
ma'am.
Case diary has come, Your Lordship.
Yes.
Where it's shown that accused, prima facie accused is involved in committing the offense. Your
What is the offense?
Uh, Possession of illegal drugs, Your Lordship, selling and buying. May I please the case diary?
Yes. Let us- You have marked it?
Yes, Your Lordship. I've checked it.
You are seeking bail for this Kiduru
Yes, Lordship.
Kiduru Lanha.
Yes, Lordship.
You seems to be prima facie involved.
Your Lordship.
And this is a
even-
drug case.
Yes, Lordship, but Lordship, she was not involved in it. She was not aware. Even the husband, this IA has told that she was not involved, Your Lordship, during the time of their arrest also, Your Lordship. She's just a victim of
But
circumstances.
this is 161 statement.
161, yes, Your Lordship.
161. Because we don't have to attach much importance, but prima facie,
Yes, Your
it
Lordship.
shows that.
Lordship, she's just a victim of circumstances and she plays no role in her husband's doing, Your Lordship. She was not aware that the drugs were at her home.
Where is your husband? He is also under confinement.
Yes, Lordship. They're both.
When were you arrested?
2623. To June 23. 2nd June 23.
What is this AET?
Oh, it stands for anti-extortion.
Anti-extortion?
Yeah, anti-extortion team.
Anti-extortion. Let us list this after a week. Okay. Next week, you may get a more considerate bench. Okay. List it after a week. Yes.
Much of
You give this to the.
My lord, I crave your indulgence to pardon me. Item number 23, your lordship. There was a interim order was, it may be.
Item 23, which
25.
Item
25, your lordship. Order detail?
Okay.
3720.
The interim order passed earlier shall continue till the next returnable date.
Returnable date. Much appreciated.
So admission, item number 27.
Yes, Mr.
Please, my lord.
Yes.
The state respondents have filed an affidavit in opposition, wherein they have clearly stated that my case shall be considered in the next page for regularization. I am a work clerk in scale bill, serving for more than 30 years in the PWD department. my
You're
lord.
still in service.
Yes, I am still in service.
Okay. So what to do? Should we postpone the case for some days just to see whether the state government is
Your Lordship, state has considered, since he has completed 30 years as a worker.
Correct.
His name is included and it has been submitted for.
If completed 30 years, learned government advocate, don't let this case come to the court because it is your own scheme. Once you complete 30 years in the scale of pay, then actually as per the scheme, you start considering.
Yes.
Unnecessarily, our people should not be allowed to come to the court because of this.
So we have done that, Your Lordship.
Yeah.
on 10th.
No, in other cases also, you advise the government. So this case is, since the government has actually considered.
If my friend agrees, then it can be closed. This case can be closed.
I leave it to the wisdom of this court, my lord. If I have no issues if it is disposed, lordship, based on the documents submitted.
Because
by the
now,
Learned Government
this
Council.
legalization process has to go to the PNR from the department. From the PNR, it has to go to the cabinet. So in the process, it usually takes time. It is not immediate. Process is there. It has to be approved by the cabinet.
It is submitted by Mr. Moemchin, the learned government advocate, that the process for considering regularization of the petitioner is in progress, and therefore 3 weeks' time may be granted, so as to please the necessary instructions on the next date fixed, listed after 3 weeks.
Deeply obliged, lordship.
Admission, item numbers 28 and 29.
May it please, my lord.
Yes,
Chief, when the matter was ready for hearing, the NPSC did not file your affidavit in opposition. So this honorable court asked the NPSC to file your affidavit in opposition, but till date they have not filed.
Lordship,
And
we
it
have-
cannot carry on like this, Lordship.
Yes, we have prepared and sent for vetting, so 1 week time may be given.
In the meantime, Lordship.
What is your IEA?
IA is the first order, interim order dated 10/8/25. Lordship, this honorable court directed the respondent not to take any action in respect with the letters they have impugned, letters they issued, that we challenge. Nevertheless, they cancelled the selection process of the 3 petitioners. So we filed this IA and in the interim, it has been stayed. So, Lordship, in that case, IA can be disposed of, Lordship.
What is IA for?
The last order is 10/8/23.
Lordship, we're not filing objection for that IA to vacate the stay, so after a week, it can be taken together along with the petition.
You file your affidavit in opposition?
Yes, Lordship, we have sent for waiting.
Okay. We give them a week's time.
Lordship.
Let them file their affidavit. Let us take up the case together. Okay.
In the meantime, Lordship, interim order dated 16/12/22 may be continued.
Okay. Your good name, please.
Ketsuker.
MS Ketsikri, the learned counsel for the
Respondent number 4.
respondent number 4, submits that the affidavit in opposition on behalf of the said respondents has been sent for waiting, and therefore a week's time may be granted to file the affidavit in opposition. Prayer is allowed, listed after a week. Stop. The interim order passed earlier shall continue till the next returnable deed.
Obliged, Lordship.
For orders, item number 30.
Please, Lordship.
Yes, Mr. Limawabang.
This condemned petition, it was filed in the year 2016. Lordship, during the pendency of this condemned petition, the respondent number 2, that is a University Crown Commission, they filed an IA 90 of 2016, paying for suspension of the present condemned petition on the ground that they filed an appeal against the order passing the petition.
Appeal before?
Yes, Lordship. This condemned petition was filed for non-compliance with the direction with the judgment in order dated 16/6/2015, passed in WPC 217 of 2015.
So appeal has been filed against that order?
Appeal was filed by respondent number 2. Appeal was dismissed. Again, against the dismissal order, again, they have preferred an SLB. The SLB also dismissed. Now, in view of the dismissal of the SLB, now that again the present condemned petition survives.
Who is for the respondent?
Respondent number 2 is a University Grant Commission.
And who is the standing counsel for the University Grant? There's a
University Grant Commission. In the appeal, one Asim Jamoki appeal. It is the order passed by the in the rate appeal. In the order passing the SLB is here.
So I think we have to issue notice.
We have to issue notice.
It was kept in abeyance.
Yes, Lordship. And Lordship, by order dated 29/7/2016.
29/7, yes.
Lordship, the IE 90 was disposed of by 29/7/2016. Lordship, can you see the order passing the IE?
Yes. Oh.
And in view of the order passing the IE, in this condemned petition also, by order dated.
So where is IA 90 case 16?
Which is in the report.
IA 90?
It's your Lordship.
No.
It's your Lordship.
IA 90 case 16, what was the order pass? 90 case 16. Which order?
29/7/2016.
Yes.
Lordship, in view of the order passing the IE in the present condemned petition, the order dated 29/7/2016. Lordship, can you see the order dated 29/7/2016? Passing the in the condemned petition. So this order has to be recalled, Lordship, now.
29/7
2016.
in your contempt petition.
Lordship, no.
Which page?
No, order passed in the condemned petition. The order passed by this one more copy. 29/7, 2016. Lordship, in view of the order passed in the ASLP, this order may be finally recalled, and the notice may be issued to the respondent.
It's a special leave petition, civil diary number 26503.
Yes, Lordship.
In view, I heard Mr. Limawabang, the learned counsel for the petitioner. Stop. In view of the order dated 10/10/2022, passed by the Honorable Supreme Court in SLP within brackets civil diary, after close bracket diary, DIARY, number NO within bracket S 26503/2020, dismissing the special leave petition, the order passed by this court on 29/7/2016 is recalled. You take steps for service of.
Lordship, the registry, since the respondent number 2 and 3, they are the University Crown Commission, they are the main respondent. They have filed the IA, so they have the notice regarding the pendency of this.
Anyhow, after the dismissal of SLP, I think.
Registry may be directed to implement.
Why are you so lazy to take steps?
Okay.
The learned counsel for the petitioner shall take steps for service of notice upon the respondent number.
1 point. Lordship, as per office note, respondent number 1
upon the respondent number.
Lordship, all the respondent. So now it's since the condemned is survived now.
Upon the respondent number.
1, 2, and 3, Lordship.
1, 2, and 3. By registered post with AD. Within a period of
3 days.
3 days from today, and shall file affidavit to that effect. Listed after 2 weeks.
Lordship, after 4 weeks, it has to go to the delay.
Okay, listed after 4 weeks. Yes.
Orders, item number 31.
Happy to Lordship.
Yes.
Lordship, as
May I please, Lordship? Lordship, I'm informed that Mr. N. Lokamir, who is in disposal, it's been instructed by the respondent number 3 to appear in this present case, Lordship. So in that view, Lordship, the council may be given a time to file the power as well as the necessary affidavits.
Mr. Swenso submits that Mr. N. Lunkamer, the learned counsel, has been engaged to represent the respondent number 3, and therefore 2 weeks' time may be granted for Mr. N. Lunkamer,
Lordship,
the
how
learned
about 3
counsel,
weeks?
to file power. Listen,
Lordship, in the meanwhile, I'll be filing my affidavit pertaining to service. I'm yet to receive the hard copies.
Yes, okay. Mr. V. Debnath shall also file the affidavit with regard to the service of notice.
Much
Obliged.
obliged, Lordship.
For orders, item number 32.
Please, Your Lordship.
Yes.
Your Lordship, here as of the office note, service upon respondent 3, the newly impleted respondent. Service is yet to be completed, as it may be least after 2 weeks.
Return service report on respondent number 3 is awaited, listed up to 2 weeks.
Much obliged.
Obligement. For orders, item number 33.
Yes.
May I please, Lordship?
Yes.
Lordship, I beg to mention on behalf of respondent number 2, Mr. N. Lokamir.
Okay.
Lordship is in disposal. So kindly list this matter after 2 weeks.
Okay.
No
Mr.
objection, my
Mr.
lord.
Swenso submits that Mr. N. Lonkamer, the learned counsel for the respondent number 2, is indisposed, and therefore seeks adjournment of the case after 2 weeks. Prayer is allowed, listed after 2 weeks.
Much obliged.
For orders, item number 34.
No, please, Your Lordship.
Yes.
Your Lordship, 2 weeks may be granted for obtaining instruction.
Okay, MS Livika, the learned government advocate, seeks for 2 weeks' time to obtain necessary instructions. Prayer is allowed, listed after 2 weeks.
Much obliged.
For orders, item number 35.
May I please, Your Lordship?
Yes.
Lordship, we have been informed that the petitioner has been appointed, so kindly grant us 1 week's time to produce the documents that the office has submitted.
You are the counsel for the petitioner. no?
Yes, Lordship.
MS Swenso, the learned counsel for the petitioner, seeks for a week's time to receive necessary instructions from his client. Prayer is allowed, listed after a week.
Much obliged.
Okay.
For orders, item number 36 and 37.
Yes.
May it please Your Lordship. Your Lordship, as per the office note, the service of notice upon the respondent is awaited, Your Lordship.
Upon respondent number, upon all the respondents, sole respondent. Sole respondent.
Lordship.
Return service report in respect of the sole respondent awaited, listed after 2 weeks.
Lordship, in item number 37, Your Lordship, it has been clubbed up together, Your Lordship. In item number 37, Your Lordship, the appellant, Lordship, that is the insurance company, Your Lordship, from 21/3/23 up till now, they are not appearing, Lordship. So, Lordship, this matter may be dismissed, Lordship, for non-prosecution, Lordship.
Where is that? Let's MSC 4/22.
4 of 22.
Let's see. 37, huh?
MSC appeal number 4 of 22, Lordship. That is
I think
item number
37.
37.
Let's see, MSC 4. What is this civil appeal? What about this? IA 85.
Lordship, the earlier IA, that is 63 of 23, that is for application for withdrawal of 50%, Lordship, of the awarded amount, Lordship.
You have withdrawn?
Not yet, Lordship. Notice is still awaited. Otherwise, also in the main appeal, after filing the appeal, they are not diligently pursuing the matter, Lordship. So from 21/3/23 up till today, they are not appearing, Lordship. Otherwise, also, Your Lordship, in the main appeal, the order dated 1/5/23, Lordship, this honorable court was pleased to give a time for ends of justice, which has been clearly mentioned, Lordship.
Have you deposited the 50%?
They have deposited, Lordship. They have. I'm for the respondent, Lordship.
Oh.
But here in the again, I'm for the petitioner.
You are for the insurance?
No.
In this.
Lordship, in the IA, that is IA 36, I'm for the petitioner for withdrawal of the 50% of the awarded amount, Lordship, and in the MSC 4 of 22, I'm for the sole respondent claimant, Lordship.
So you want to withdraw this 50% also?
Lordship.
MSC 4. MSC 4, no? This is item, MSC 4 is item 37, no?
Lordship.
On 21/3/2023, 10/4/2023, and 1/5/2023, when the matter was called, there was no representation on behalf of the appellant. Stop. Today also, when the matter is called, there is no representation on behalf of the appellant. Stop. It appears that the appellant is not interested to prosecute the case. Accordingly, the MSC appeal stands dismissed.
Lordship.
Then in this IA 85, na?
Lordship.
IA 85. When was it deposited?
Lordship.
And by which order it is reflected?
Lordship, by order dated 23/6/22, Lordship, in the IA 85.
23/6/22, the impugn shall be.
The appellant was directed to deposit, Lordship.
No, yeah, it was directed to be deposited, but was it deposited?
Lordship, by order dated.
Here in the office note, it says that 50% of the awarded amount. Oh, this
On
is one.
16/2/23, it has been deposited.
On
16/2/23.
Whether that is recorded?
Lordship, it's in the office note, Lordship.
16/2.
Yeah, Lordship. By check number 213089 dated 31/23. Office note dated 16/2/23, Lordship.
Office note dated
16/2/23. It was deposited on that day, Lordship.
This rupees 15 lakhs 2,000.
Lordship.
This is that 2,000. So this order has to be passed in the main
Lordship,
in the main appeal.
Lordship, this order has to pass in the IA 63, Lordship. That is the application for withdrawal of the deposit of 50%, Lordship.
Heard, Mr. So-and-so, then counsel for the applicant. This is pursuant to which order?
Lordship.
This deposit is pursuant to which order?
Lordship, order dated 23/6/22, Lordship, whereby the appellant was directed by this honorable court.
23/6/2022.
Lordship, 23/6/22.
23/6/2022. No, nothing is reflected. In the miscellaneous or main?
In the Lordship, in the 85 of 22, IA 85 of 22, Lordship.
In IA 85.
85 of 22.
So we have to pass the order in IA 85.
Lordship.
85.
Lordship.
And what is 63?
63 is my IA for application for withdrawal, Lordship.
And what is 85?
85 is for stay. That was filed by the appellant.
Okay, 85, no?
Lordship.
In view of the order passed in MSC Appeal 04 of 2022. This is IA 85, okay? The IA stands disposed, okay?
Lordship.
Okay, now we come to 63.
Lordship.
Now this is, by which order 63?
23/6/22.
23/6/23.
Passed in the IA 85. By order dated 23/6/22, passed in the IA 85 of 22, the appellant was directed to deposit the 50%, Lordship. 23/6/22.
And this is IA 85, okay. IA 63.
Lordship.
63.
Lordship.
Heard, Mr. So-and-so. The learned counsel for the applicant. The office note dated 26/2/2023 or 16.
16/2/23.
The office note dated 16/2/2023.
They have deposited, Lordship. White check number 213.
In MSC Appeal 04 of 2022. States that the amount of rupees 15,150,2,165 in words also you give, okay, 15 lakhs and so, which is the 50% of the awarded amount, has been deposited by the appellant insurance company, white check number 213089
Lordship.
on 31/20/23. The registry, the applicant is accordingly allowed to withdraw the amount after proper identification of the petitioner by the registry. The IA 63/2023 accordingly stands disposed. Okay?
Obliged, Your Lordship.
Yes.
Unlisted motion, anticipatory date 31 of 23. Please, my lord.
Yes, Mr. Santiago.
Lordship, the case pertains to dishonor of check, and the maximum punishment is only 2 years, Lordship. Now, the complainant and the accused here, Lordship, the applicant, they are very well known to each other, that they have been good friends for so many years, Lordship. And they jointly decided to invest in a centrally sponsored scheme in New Delhi, Lordship. Now, however, unfortunately, both of them invested in the scheme, in the project. And the applicant, the accused, he wants to run around in the offices meeting the persons concerned. However, the project did not materialize on time. And the complainant, who had invested 26 lakhs 60,000 into the...
Why state is implemented?
My lord, since direction has been given, Lordship, to the SP, Lordship, to issue non-bailable warrant of arrest by the Chief Judicial Magistrate. Now, Lordship, I have full intentions to...
Where is that order?
Annexure 6, Lordship.
Annexure 6 of which page?
Page 35, page 36 is the type copy, Lordship.
Page 36.
Yes, I've already paid a substantial amount during the pendency of the...
Just wait. Let us wait for the merit. Let's see.
That copy is page 36, the last
36,
page.
correct. It is.
In fact, the complainant's counsel also did not press for issuing this warrant, Lordship.
Okay.
Despite the case being pending, we still respect each other, Lordship.
That is why the CR case against you.
Yes, Lordship. In fact, I also understand Lordship, his apprehension. I've also offered him to take my land also, Lordship, but he refused. My land is below the Assam Rifles helipad in Liri Colony.
This case pertains to Kohima?
No, Lordship, Dimapur. The accused, he is from Kohima, but the check was drawn at ICICI branch, Dimapur, so the case was filed there, Lordship.
But Mr. Santiago, the learned counsel for the applicant. Stop. And also Mr. Kya Angami, the learned public prosecutor for the state respondents. Stop. This application has been filed under section 438 of the Code of Criminal Procedure Code, 1973, seeking for grant of anticipatory bail to the applicant against the order dated 25/8/2023, passed in CR case number 02/2022 by the learned Chief Judicial Magistrate Dimapur under section 138 Negotiable Instruments Act. Issue notice to the respondents, returnable within 4 weeks. Since the state respondent is represented by Mr. K. Angami, the learned PP, no formal notice need be issued. Stop. Insofar as the respondent number 2 is concerned, the learned counsel for the applicant shall take steps for service of notice upon the said respondent by registered post with AD within a period of
3 days, my lord.
Within a period of 3 days from
Lordship, I may also be allowed to serve by way of trustee, Lordship. to the respondent too.
Shall take steps, just here, shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by dusty process.
My lord,
within a period of 3 days from today, okay? In the interim, it is ordered that the order dated 25/8/2023,
my lord,
passed by the Leonard CJM
Dimapur,
and Civil Judge Senior Division,
my lord,
Dimapur, in complaint case number 2.
yes, my lord,
Why so many zeros?
yes, my lord,
In complaint case number
2, yes, case number
slash
2 of 2022.
2022 shall remain suspended till further orders of this court. The applicant is also accordingly granted ad interim anticipatory bail till the next returnable date, listed after 4 weeks.
Deeply obliged, my lord.
Admission, item number 6.
May I please, Your Lordship?
Yes.
My senior is still in court number 2. So if this may come up after break.
Court number 2, who is open? MS so-and-so, the learned counsel for the petitioner submits that the leading counsel, Mr. Imti Longcham, is on his court in court number 2 and therefore seeks adjournment of the case after a week. Okay. Listed after a week.
Much obliged, Your Lordship.
For hearing, item number 39.
May I please, Lordship, before your Lordship takes up the hearing matter, upgraded item number 44, 45, and 46, Your Lordship.
44.
Here, Your Lordship, the counsel for the petitioner is not present today. He is from Dimapur.
Okay.
If the matter may be fixed.
So we'll record his absence?
On Monday.
We'll record his absence?
Huh?
It's okay, Your Lordship. That can be recorded.
Okay. 44, 45, 46, correct?
Why not?
None appears for the petitioner. Listed after 2 weeks.
If it is convenient for Your Lordship, on 4th, Your Lordship, next Monday.
Listed on 4th September, correct?
Monday, Your Lordship.
Why not the 5th?
Lordship, no.
Listed on 5/9/2023. Okay?
Obliged, Your Lordship. I'll inform you.
Please, please. Just inform him that he has been shown absent.
No.
For hearing, item number 39.
Your Lordship,
Yes, please.
your counsel has overlooked the item, so kindly allow for 2 weeks.
Who is the counsel for the petitioner? Theo.
Yes.
Theo.
Yes.
You are Nisi.
On behalf of Theo.
Okay. Mr. So-and-so makes a mention on behalf of Mr. Theo, the learned counsel for the applicant, and seeks adjournment of the case after a week. Prayer is allowed, listed after a week. Okay?
For hearing item number 41.
Take this. Yes, Mr. Dimomi.
Yes, my lord. It's a short matter, my lord.
Yes, yes.
It's a very short matter. The Nagaland Engineering Service Rules.
Yes, wait, yes. Yes, please, yes.
Yes, Your Lordship. So, in a nutshell.
Yes.
In a nutshell. The Nagaland Engineering Service Rules provides that those who...
Which year?
Both, Your Lordship. The old one as well as the new one.
Okay.
So, it provides that those who have the PhD, who acquire the PhD qualification, they will be given advance increments.
Okay.
Now, the petitioner has secured the PhD degree. He has not been granted the advance increments, and the reason is because in the year 2004, some resolution was adopted that those who secure additional qualifications, they will be given some lump sum benefits in cash, but they will not be given advance increments.
Okay.
So there is a decision, an executive decision, and on the other side, there is a statutory rule which provides that those who secure or those who get the additional qualifications, they will be given advance increments. That's a short case. That's a short.
Okay. So it's a conflict between the statutory rules and the executive instructions.
Short matter.
Okay.
Short. So, if you may go to the petition, my lord.
Yes.
Paragraph 3, page 3, annexure A, page 12, the appointment of the petitioner. So, this is pursuant to a selection process.
Page
3.
Page 3.
Yes, not page 3 of my petition. Acts about his appointment process.
Okay.
I wish to place that before you.
Just wait.
Yes. Yes.
Yes, please.
So, my lord, pursuant to a selection process conducted by the NPSC by notification dated 18/6/2007, the petitioner was appointed as a subdivision officer SDO in the Department of Works and Housing. At the time of entry to service, the petitioner had a degree in civil engineering. So, at the time of entry, he was just a graduate.
Okay.
Then, number 3. That being desirous of acquiring a higher education qualification, the petitioner applied for study leave in the year 2011. On permission being accorded, the appointment orders at annexure A at page 12. So would it be necessary to go to the appointment order, Your Lordship?
Yes, just wait. On permission being recorded, the petitioner secured admission.
In the Indian Institute of Technology, Delhi, one of the premier institutions, Your Lordship. On successful prosecution of the course by a certificate dated 4/11/17, the petitioner was awarded the degree of Directorate of Philosophy. The subject chosen by the petitioner for doctorate study was enhancing fly ash utilization in concrete. So the date, Your Lordship, is 4/11/17. Lordship, may kindly note that.
Completion, that is completion.
Yes, Your Lordship. 4/11/17.
Yes, please.
Then the next paragraph, Your Lordship. This is about the rules now. The service in the Department of Works and Housing is governed by statutory rules in the naming style of the Nagaland Engineering Service Group A and B Rules of 2012. You will also refer to as the Rules of 2012. The Rules of 2012 was preceded by the Nagaland Engineering Service Class 1 and Class 2 Rules of 2006. You will also refer to as the Rules of 2006. For the purposes of the instant petition, Rule 13 of the Rule of 2006 and Rule 12 of the Rules of 2012 are reproduced hereunder. Rule 13 of the Rules of 2006, Your Honor. A candidate for direct recruitment or departmental promotion should possess the academic and technical qualifications prescribed against each post in Schedule 6. For direct recruitment, the commission shall verify recognition by University Grants Commission and AICTE for degree and diploma respectively for the purpose. A candidate with postgraduate degree on being selected through competitive examination and appointed to any grade shall be entitled to 3 advance increments in the time scale of his pay. So this was the prescription in terms of the rule of 2006. Now the next page, Your Worship, is the rule of 2012 now, and the rule is Rule 12. A candidate for direct recruitment or departmental promotion shall possess the academic, technical, and other qualifications prescribed against each post in the schedules from any of the universities and institutions recognized by the central state government. A candidate with postgraduate degree, on being selected through a competitive exam and appointed to any grade, shall be entitled to 2 advance increments in the time scale of his pay from the date of completion of the postgraduate degree. Simultaneously, a candidate with doctorate degree shall be entitled to 3 advance increments in a time scale of his/her pay from the date of the doctoral degree. So we are concerned with this provision, Your Worship. Simultaneously, a candidate with doctorate degree shall be entitled to 3 advance increments in the time scale of his/her pay, so already in service, from the date of completion of the doctoral degree. Then these are the 2 rules which govern the field now, Your Worship. And we are more concerned with Rule 12 of the rules of 2012. Because we entered into service in the year 2007, Your Lordship. I entered into service in the year 2007. So the rules of 2012 now apply.
Yes, please.
And paragraph 5, that the above referred rules specifically provide for granting 3 advance increments to a candidate who acquires the PhD. In contrast, the Department of Health and Family Welfare is governed by the Nagaland Health Service Rules 2006. Pertinently, the rules of the said department do not provide for advance increments on acquisition of higher qualifications. The petitioner craves the leave of this honorable court to refer to and rely upon the aforementioned rule at the time of hearing. Now, why this reference, Your Lordship? A very interesting point here. Why this reference? Insofar as the Department of in the Nagaland Health Service Rules of 2006 is concerned, there is no provision for advance increments for those who acquire a PhD degree or postgraduate degrees. Yet, doctors who acquire a PhD degree, they are given advance increments. For us, we have statutory rules. Doctors, we do not have statutory rules. That's why I'm drawing your attention.
That's okay.
Yes. Then the paragraph 6, that in the year 2014, state respondents in the Department of Personnel and Administrative Reforms issued office memorandum dated 17/6/2014. By this office memorandum, the concept of a lump sum incentive for those who acquire higher qualification in lieu of advance increments was introduced. Now, this is where the problem is crept in, Your Worship. If you may go to page 14.
Just wait. Just read again, Mr. Jamomi.
That in the year 2014, state respondents in the Department of PNAR issued office memorandum dated 17/6/14. By this office memorandum, the concept of a lump sum incentive for those who acquire higher qualification in lieu of advance increments was introduced. This is the office memorandum. So instead of giving advance increments now, you will be given lump sum incentives.
So this is the impugned memorandum.
Yes, ma'am. Yes. If you may go to the memorandum in question, which is at page 14.
Page 14.
Page 14.
Yes,
may I read my note? This is 17 June 2014. The subject is review of granting incentives to government employees who acquire higher qualification by availing study leave. 1. Presently, the state government employees who have put in 2 years or more in service are granted study leave as per CCS Leave Rules 1972 and amended from time to time. And in acquiring higher qualification, they are given increments based on their respective departmental service rules, which vary from 1 increment to 6 increments. Now, the Government of India has issued a notification stipulating that in lieu of increments, some incentives will be given to the employees as per Stop. As per FR 2716, government employees who acquire higher qualification by availing study leave will also not be eligible for grant of any incentive. 2. The state government has now decided to discontinue grant of incentives to the state government employees who acquire higher qualification by availing study leave. The lump sum incentive in replacement of the existing increment will now be given to the employees as per provision in FR 2716. All the departments are therefore requested to convert the existing increment-based incentive already incorporated in their service rules into a one-time lump sum incentive as detailed below with immediate effect. This amount will be reviewed as and when the government of India modifies it, and the various lump sum incentives. Then 3. The following provisions for guiding the principle of incentives are as follows. 1. The incentive will not be available for the qualifications which are laid down as essential or desirable qualifications in the recruitment rules for a post. No incentive shall be allowed for acquiring higher education purely of an academic or literary subject. Incentive should be considered only if the higher qualification will make the official more effective in the present or next higher assignment. Incentives need not be considered for qualifications like MBA or degree in humanities. Next page, on. The incentive will not be admissible where a government servant is sponsored by the government or she avails of study leave by acquiring the qualifications. No stepping up of pay shall be allowed in the case of juniors by virtue of drawing more pay under the scheme of advance increments. 3. The acquisition of the qualifications should be directly related to the functions of the post by him, her, or the functions to be performed in the next higher post. No incentive would be admissible if an appointment is made in relaxation of the education qualification. No incentive would be admissible if employee acquires the requisite qualification for such appointment at a later date. Any clarification arising out of the provision of this scheme may be referred to the PNR department for decision of the government. Further, the existing procedure for sending the file to the PNR department for granting of study leave to the government employees would still continue. Any department to consider extension of the incentive scheme to qualifications other than those listed in the respective service rules shall be done only with the prior approval of the PNR department. So instructions were issued, and instructions were issued based on certain decisions taken by the central government. Fact of the matter is, Your Lordship, the rules are still subsisting. Rules are still subsisting. The rules are still subsisting. Now, can you go to the next paragraph in the petition?
Now, what about this? All the department are therefore requested to convert the existing increment-based incentive already incorporated in the service rules into one-time lump sum incentives.
Yes.
What about this?
So, therefore, Your Lordship, this can be treated as a direction to the departments to amend the service rules. Nothing done so far. Nothing done so far.
Yes, please.
Your Lordship, paragraph 7 now, at page 6.
Your petition.
My petition. Yes, sir. Well, I'm going through the paragraphs because the facts are important.
Yes.
And the facts relate to the dates also.
It's all right. It's all right.
Paragraph 7. That the state respondents took the date of issue of the aforementioned memorandum as the cutoff date following advance increments. So 17/6/2014, that is the date of the memorandum. The state respondents took this date as the cutoff date for allowing advance increments. Also, by an office memorandum bearing 5/7/18, the minutes of the cabinet meeting held on 4/7/18 was circulated. At agenda 5 of the said minutes, the memorandum dated 17/6/14 was modified and the advance increment for medical doctors and acquiring higher qualifications was restored. So again, the office memorandum was again qualified at page 16. Lordship, we can come to page 16. And this is a circulation of the minutes of the cabinet meeting held on 4/7/2018.
With regard to medical?
A whole lot of decisions. And with regard to medical, that was one of the agendas. At page 17, agenda number 5.
This is your para 7 relevant.
Agenda number 5. May I read, Madam?
Just
agenda number 5, review of
just one second.
So even the office memorandum dated 17/6/14 is not being strictly followed. Agenda number 5, has your lordship got that? At page 17?
Yes.
Agenda number
At
5.
page 17, correct.
At the bottom of the page, agenda number 5. Review of granting incentives to government employees who have acquired higher qualification by availing study leave. The cabinet discussed and approved to exempt the medical doctors in partial modification of the PNR memorandum dated 17/6/14 and restore the grant of incentives to the medical doctors for acquiring higher qualification. The department was further asked to examine the issue of grant of study leave for specialization and bring it before the cabinet. A special exemption for doctors. Special exemption for doctors from the purview of the office memorandum dated 17/6/2014.
Yes.
Can we proceed again, Your Lordship?
Yes.
Paragraph 8. Paragraph 8 of my petition.
Yes, please.
Paragraph 8, that upon award of the PhD, the petitioner submitted representations for the grant of advance increments. However, the representations submitted were rejected. After the review in respect of medical doctors as above referred, the petitioner along with other colleagues submitted representations dated 26/7/18. On similar lines, 2 other colleagues also submitted representations dated 26/7/18. The representation submitted by the petitioner and another was forwarded by letter dated 26/7/17. By this letter, the department recommended the grant of increments as per the relevant service rules. So even the department recommended the award of increments in terms of the relevant service rules. Subsequently, by notification dated 22/8/19, the petitioner's colleague, the person with whom the petitioner submitted the representation dated 26/7/18, was allowed 2 advance increments. By another notification dated 22/8/19, the petitioner's other colleagues who had submitted representations were also allowed 2 advance increments. Though not specifically mentioned in the orders itself, the rationale for the grant of the advance increments to the petitioner's colleagues can be ascertained from the note of the Department of PNR dated 5/8/19. So can we go to that note, Your Lordship? And all these documents are annexures E to annexure J, beginning from page 21. Anyone is my representation. May I read, my lord?
Yes, please. Page 21 to?
Page 21 to 26. Page 21 is my representation.
Yes, please read.
Yeah, may I read, my lord? This is 26 July 2018. And this is a joint representation. Your Worship, kindly note, there are 2 persons. The first person is myself, and the second person is Lee.
Yes.
In inviting reference to the subject cited, we undersigned would like to say a few lines with regards to the advance increment. We had earlier applied for grant of advance increments on account of acquiring higher qualification, but the same was not granted to us on account of OM dated 17/6/14. However, the matter was recently re-examined by the PNR OM branch, finance department, and the cabinet, and the medical doctors have been granted incentives to acquire higher qualification via Health and Family Welfare Department notifications. The following are the details. 1, Dr. Quito Murami, that is me, SDO, number of increments 3, education qualification, PhD, civil. Then reference, rule number 12 of the Nagaland Engineering Service Rules, Group A and Group B, Rules 2012. Number 2, Architect Kevisano Angami, Assistant Architect, 2, Master of Planning, same rules. So this person, Your Worship, did not acquire PhD, he acquired Masters after the graduate degree. So 2 advanced increments were given to him. In line with this, we are hereby requesting you to consider our case and pursue the matter to the government for the needful action for granting us the advanced increment as provided in the relevant service rules. Then, next letter, Your Lordship. Letter F. 2 other persons who applied. 2 other persons who applied. This is 26 July 2018. In inviting, in reference to the subject cited, We at the Unsigned would like to say a few lines with regards to the advance increment. We had earlier applied for grant of advance increment on account of requiring higher qualification, but the same was not granted to us on account of OM dated 17/6/14. However, the matter was recently examined by the Finance Department, PNR Department, Finance Department, and the Cabinet, and the medical doctors have been granted incentives who acquire higher qualification by health and family welfare notification, etc. The following are the details. So the details of the two persons. So these two persons also, they acquired the master's degree. These two persons. And the next page. Next page, 20th July 2018. This is addressed, this is by the Office of the Engineer-in-Chief, and it is addressed to the Commission Secretary. Grant of increments and requiring higher qualification. So, with reference to the subject cited, I am to state that the following officers working on NPWD are applying for advanced increment on account of acquiring higher qualification. Earlier, the incentives for higher qualification was discontinued by OM dated 17/6/14. However, the matter was examined by the PNR, Finance Department, and the Cabinet, and the medical doctors are now granted incentives who acquire higher qualification by health and family welfare notification dated 16/7/18. The following officers are applying for the advanced increments. One, that is Quito Nurmi, that is myself, and number two is my colleague. And the reference, in the reference column, Your Lordship will see rule number 12 of the Nagaland Engineering Service Rules, Group A and Group B Rules 2012. The department therefore recommends, the last sign, Your Lordship, the department therefore recommends the case for grant of increment as per relevant service rules. And the next page. This is 22nd August 2019.
Yes.
As per the provision under Rule 11 of the Nagaland Engineering Service Rules of 2012, the Governor of Nagaland is pleased to notify granting of 2 advanced increments to Architect Kirisun Lami, Assistant Architect for holding postgraduate degree. Details are given below. This is the colleague with whom I submitted a joint representation.
Okay.
And in the remarks column, Your Lordship will see effective date of advanced increment 5/6/2013. My Lord may kindly note the date 5/6/2013. Then the next page.
Yes.
This is dated 22nd August 2019, and this is in respect of the other 2 persons who submitted representations. As per provision under Rule 11 of the Nagaland Engineering Service Rules of 2012, the Governor of Nagaland is pleased to notify granting 2 advanced increments to following engineers for holding postgraduate degrees. Then, Engineer Chanovicho.
This is as per the rules.
Yes.
As per the rules 2012.
2012. Effective date of advanced increment 13/12/2012. 13/12/2012. And the next page. Next page. The picture is very clear. This is the note of the Department of PNR. This is, the matter has been examined in consultation with Finance Department, and their observations are appended below for information. The Finance Department has examined the case regarding grant of advanced increments to engineers, architects under NPWD for acquiring higher qualification and convey the following. As in the case of veterinary doctors, engineers, architects cannot be equated with medical doctors for grant of advanced increments. Now, look at the reasoning here, Your Lordship. We cannot be equated with doctors. We have statutory rules which provide for us. Doctors do not have statutory rules which provide for them. And number 2, however, engineers, architects who had acquired higher qualification prior to the discontinuation of advanced increments by PNR memorandum dated 17/6/14 should be finalized with reference to the prevailing rules orders. So when it says 6/14, it's taken out the cutoff date. So only those who acquired the higher degree prior to 27/6/2014 shall be promoted in accordance with the rules of 2012. That's what they are saying. So those who acquire the higher degree after 17/6/2014.
Read this para 2 once again.
However, engineers, architects who had acquired higher qualification prior to the discontinuation of advanced increments by memorandum dated 17/6/14 should be finalized with reference to the prevailing rules and orders. So the rules will be applicable only to those who acquired the higher qualification prior to 17/6/2014. And for those who acquire qualification after 17/6/2014, they will not be.
So yours is after 17/4. 2016.
Your Lordship, I acquired the higher degree in 2017,
2000.
after the office memorandum dated 17/6/2014. So since I acquired the higher qualification after the issuance of the memorandum dated 17/6/14, the rule will not apply to me. Effectively, that is what the state is saying.
What is the basis of that classification?
That is why, that is precisely the point, Your Lordship. How can how can the state go against its own rules? And the law is well settled, my lord. Executive instructions cannot override the rules.
Yes, yes. Yes, yes, resume at 2. Okay. Yes, Mr.
Yes, my lord. So if I may continue, my lord, just,
Yes, yes.
just a clarification about one of the annexures, which is at page 25. At page 25. The two other persons who had submitted representations, just like the petitioner. And in the column showing year of completion, your lordship will see 2010, 2010. Though the effective date of advance increment is the rules of 2012, apparently they completed their postgraduate degrees in the year 2010. So the rationale is...
This is a master's degree?
Yes, master's degree. Master's degree in 2010. So the rationale of the note of the PNAR, which we were discussing last time, your lordship, is 17/6/2014. So those who had acquired their additional qualifications prior to 17/6/2014, the rules were made applicable to them. And those who acquired the PhD, for me, since I acquired the PhD degree in the year 2017, the rules were not made applicable to me because of this office memorandum dated 17/6/2014. So the office memorandum dated 17/6/2014, that date was taken as a cutoff date.
This page 26?
Yes, yes, madam. Page 26. This is a note of the PNAR, and this is the explanation. May I read again the second paragraph,
Yes,
my lord?
please, please.
The second paragraph, may I read again, my lord?
Yes.
However, engineer architects who required higher qualification prior to the discontinuation of the advance increments via office memorandum dated 17/6/14 should be finalized with reference to the prevailing rules orders. So those who were acquired prior to the office memorandum dated 17/6/14, only to them the rules will apply. The provisions of the rules which allows advance increments will apply to only those who acquired the higher qualifications prior to 17/6/2014.
So you acquired your doctorate after 17/6/2014?
Yes. That is the rationale now, Your Lordship. The rationale is very clear. Since I acquired my higher degree after 17/6/2014, I will not be permitted the benefits of Rule 12 of the rules of 2012.
Yes, please.
And in fact, Your Lordship, this is the only defense set up by the state respondents, as far as I am concerned. The only defense. The single defense, the only defense.
Yes, please.
Now, if you may go to the affidavit filed by the states, by the state respondents, Your Lordship.
Yes, wait.
The affidavit filed by the respondents numbers 1, 2, 3, and 4.
Just wait, Mr. Edmumi. Yes.
Affidavit of the respondents 1, 2, 3, and 4. It's a very short affidavit, Your Lordship.
Yes, yes. 1, 2, 3, and 4.
Yes.
Yes, please.
Now you can put, 1, 2, 3, 4, paragraphs 1, 2, 3, and 4. Now, Basically, the state respondents do not dispute certain points.
Okay.
The first point is this, that the medical department does not have service rules which provide for advance increments.
Yes, please.
Second is that the state respondents themselves relax the notification dated 17/6/14 in respect of doctors.
OM dated?
17/6/14. 17/6/14.
In respect of the doctors.
In respect of doctors.
Yes, please.
Thirdly, is the date of the notification, 17/6/14, was by itself treated as a cutoff date.
Was itself treated as?
As a cutoff date, 17/6/14, by which the increments was taken away and a lump sum incentive was granted. Your Lordship will recall that incentive, that office memorandum. So the date of issuance of the notification, office memorandum, that is 17/6/14, that itself, that date itself was treated as a cutoff date.
This is for denying the increment.
Yes, my lord.
Yes, please.
And taking that date as a cutoff date, the person who had, along with whom I had submitted a joint representation, he was allowed the advance increments.
Yes, please.
Two other persons who had also submitted representations in similar manner,
Yes.
they were also allowed advance increments.
Yes.
Your Worship, all these admissions are in paragraphs 1, 2, 3, 4, and paragraphs
1, 2, 3, 4.
1, 2, 3, 4, and 8 of the state's affidavit. Respondents 1, 2, 3, and 4. Paragraphs 1, 2, 3, 4.
1, 2, 3, 4.
And then paragraphs 8 and 9.
1, 2, 3, 4.
And paragraphs 8 and 9.
8 and 9.
Then, Your Lordship, the only defense which I was referring to earlier, Your Lordship, the only defense of the state is contained in paragraphs 5, 6, and 7.
What are 5?
6 and 7.
Yes, please.
May I read these three paragraphs?
5, 6, and 7.
5, 6, and 7.
Yes, yes.
That with regard to the statements made in paragraphs 10 and 11 of the writ petition, the deponent states that the petitioner's colleagues were considered for the increment as they had acquired the higher degree prior to the issuance of the office memorandum dated 17/6/2014. Whereas the petitioner's case could not be considered as he had acquired a doctorate degree only in 2017. It is also pertinent to mention here that even as per the Nagaland Engineering Service rules of 2012, a candidate with doctorate degree shall be entitled to 3 advance increments in the time scale of his or her pay from the date of completion of doctoral degree. As such, the question of bias or arbitrary action on the part of the respondents does not arise. So therefore, Your Worship, on one part, they say that, in the first part of the paragraph, they say that my colleagues had acquired their additional degrees prior to 17/6/2014, but I got it in 2017, therefore it was not given to me. In the next paragraph, they acknowledge that in terms of the rules of 2012, a candidate with a doctorate degree shall be entitled to 3 advance increments. They themselves say that the rules allow for this. And then in the next bit they say, as such a question of bias or arbitrary action does not arise. This is a totally contradictory paragraph. The state respondents contradict themselves. Then paragraph 6.
So according to the government, rules 2012 is still in force?
Yes, it is. It is. It is. And paragraph 6 then, madam.
Yes, wait. Yes, please.
Paragraph 6.
Yes.
That with regard to the statement made in paragraph 12 of the petition, it is stated that as per the service rules 2012, the petitioner will be entitled to 3 advance increments in the time scale of his pay from the date of completion of the doctoral degree. Again admitted. As the petitioner acquired the doctorate degree only in 2017, no accrued rate has been denied to the petitioner. Again, a contradictory statement, followed by a contradictory statement. Then paragraph 7, that with regard to the statements made in paragraph 13 and 14 of the petition, the deponent states that the OM dated 17/6/14 only lays down the guidelines. Now they say it is only guideline for granting of incentives to government employees who require higher qualification. Therefore, the question of overriding statutory rules does not arise. Then again they acknowledge that the rules will prevail.
Yes.
In the face of their admissions alone, Your Lordship, this petition deserves to be allowed. And not only just admissions, Your Lordship, they cannot deny it because the rules still exist. The rules have not been repealed. So therefore, in terms of the rules, Rule 12, I am entitled to advance increments from the date I acquired my doctoral degree. And that date, Your Lordship, is the certificate which is dated 4/11/17, which is Annexure B at page 13 of my writ petition.
Three advance increment.
Yes, my lord. For a PhD holder, yes. 3 advance increments. Since they rely
So 2017, you acquired your degree?
Yes, my lord.
Yes. Okay.
So therefore, my lord, the office memorandum dated 17/6/14 is bad in law by their own admission. It is bad in law.
17/4/2000?
6. 17/6/14, Your Lordship.
17/6/14. 17/6, the OM, huh?
Yes, my lord.
17/6/2014.
17/6/14, which is Annexure C at page 14 of the writ petition.
Yes.
So I have impugned this notification, Your Lordship. But Your Lordship will appreciate it is not even necessary to impugn the notification. Statutory rules are in force, statutory rules are in place, so there is no question of an executive instruction overriding statutory provisions. So that concludes my submission, Your Lordship. I'll just place 3 authorities for Your Lordship's consideration.
Please, please.
Your Lordship, I've just culled out the principles. These are all settled principles of law.
Yes.
May not,
Your citation?
I have handed over a list now.
Okay.
So the first citation is 1998, 8 SCC 469.
Yes.
Paragraph 3. Statutory rules prevail over executive orders or executive practice. Merely because the government has taken a decision to amend the rules do not stand obliterated. Till the rule is amended, the rule applies.
Yes, that is the law. That is the law.
And the second one, Your Lordship, is 2004, 12 SCC 588. In law, if an executive instruction is contrary to statutory rules, the rules will prevail and not the executive instruction. All settled principles, Your Lordship. The third one, 2014, 8 ACC 644, paragraph 28. Executive orders cannot supplant the rules. Executive order can only supplement the rules. Settled principles. No need to read the paragraphs, Your Lordship.
Correct.
Settled principles.
Yes.
So that's my case, Your Lordship.
Okay.
May I rest for a moment?
Yes, Mr. Ngami.
Please, my lordship, my learned senior friend has already take my lord to my affidavit paragraph 5, 6, and 7.
Yes.
And in the so I'll not repeat, but I'll start from paragraph 7, lordship.
7.
Yes.
Yes, please.
Allow me to read, lordship.
Please, please.
That with regard to the statement made in paragraph 13 and 14 of the petition, the deponent states that the office memorandum dated 17/6/2014 only lays down the guidelines for granting of incentive to government employees who acquired higher qualifications, lordship. Where the state is not denying him.
What about the next line?
Yes, therefore, the question of overriding statutory rules does not arise. Lordship. The government is not denying him increment, lordship.
Government is not denying him increment.
What government is saying is, we'll grant him as per the memorandum, lordship.
No. What about the rules?
Lordship, but
what about the rules?
And
I hope you know the law very well.
I know right or wrong. Allow any condition to that.
Please.
Lord, allow me to take you to Annexure 14 of the petition, lordship.
Annexure 14 of the petition.
Lordship.
In the writ petition.
Lordship.
Annexure 14. Page, please.
Page 14.
Page
14.
Okay. Page.
Paragraph
14.
Paragraph.
So this is page 14. Annexure C. Yes, please, Kevi.
Lordship, paragraph, allow me to read paragraph 1 and 2 again, lordship.
Para 1 and 2, correct?
Yes,
Just wait.
Presently, the state government employees who have put in 2 years or more in service are granted study leave as per Central Service Study Leave Rules 1972 and amended from time to time. And on acquiring higher qualifications, they are given increment based on their respective departmental service rules, which vary from 1 increment to 6 increments. Now, the government of India has issued notifications stipulating that in lieu of increments, some incentives will be given to the employees. Now, lordship, the next line will be important. As per FR 27/16, government employees who acquired higher qualification by availing study leave will also not be eligible for grant of any incentives. Next paragraph, Lordship. The state government has now decided to discontinue grant of incentive to the state government employees who acquired higher qualification by availing study leaves. The lump sum incentive in replacement of the existing increment will now be given to the employees as per provision in the FR 27 clause 16, as per provision in the FR 27/16, Lordship. All the departments are therefore requested to convert the existing increment-based incentive already incorporated in their service rules into one-time lump sum, incentive, as detailed below with immediate effect. This amount will be reviewed as and when the Government of India modifies it. And now the petition falls under 3 increments, Lordship. 3 increments. So the government says that he is entitled 6,000 as 3 increments. What the stand of government is, he is entitled for 3 increments, even the service rule. And this is the guiding for granting of incentives. This memorandum is guiding for granting incentives. And as per this, he is entitled 3 increment, that is 6,000, Lordship.
Mr. Akibo, what is your increment, entitlement of your increment?
Your Lordship, in terms of the pay scale.
In terms of the
In
pay
terms
scale?
of the pay scale, yes. And that accumulates over the years, Your Lordship.
Achha.
As Your Lordship will be aware. But this is a lump sum one-time payment.
But this is called 3 increments. Whether
Lump sum payment, Your Lordship. No. That's a wrong submission, Your Lordship.
No.
Can you, just wait, Mr. Ejimomi?
Yes, ma'am.
Can you kindly just, can you particularize about your increment?
Your Lordship, the pay scale.
Is it in your petition?
The pay scale, it's not in the petition, Your Lordship. For example, if Your Lordship may kindly see, the appointment order.
The appointment order is in?
Yes. Page 12.
I'll hear you.
Page 12. Page 12. Your Lordship may kindly see.
Just wait. Page 12, okay?
Yes.
Yes, page
12. This is the appointment order of the petitioner, the initial appointment order.
Page 12. Yes.
So his pay scale is 8,000-275 dash upper limit of 13,000 per month. So 275 is the increment, Your Lordship. 275 rupees is the increment. So he moves along that pay scale with this increment. So 3 advance increments means he will get 3 advance increments of this. So this cumulatively, Your Lordship, over the years, this cumulatively places him in a pay scale which is accrued over the years. So every year, the pay scale will increase on the basis of increments received. The actual pay received will increase on the basis of increments.
So I'm acquiring the degree.
Yes.
The higher degree.
Yes.
He will be entitled to 3 increments of 275.
Yes. Something like that. 275. 3 advance increments.
3 advance increments.
Yes.
So his scale of pay will also
go higher. Yes. And every year it will increase because of that. Now that is taken away. Your Lordship may kindly come to 14, which the government advocate is relying upon.
His?
In my petition.
Yes. 14 is that office memorandum.
Yes. So what this office memorandum seeks to do is that for those, it is not 3 increments equals 6,000. Not at all, Your Lordship.
Lump sum.
Yes. For those who are getting 3 increments, they will get a lump sum of 6,000.
Lump sum once.
Yes. A lump sum.
Okay, I understood. Okay.
That is not a correct statement, Your Lordship.
Yes. Okay, Mr. Kangami, please continue.
So this lump sum 3 increments he's entitled, that is what the stand of the government, Lordship. And as per this is just a guideline for granting incentives. But had he passed before, obtained his doctoral degree before 2014, like he's under.
But Mr. Kiangami, what is the basis of the classification acquiring degree prior to 2014, after 2007, after 2014? I think there should be some basis, and the government has to justify that.
Lordship, that is why here he said, as per FR Fundamental Rule 2716, that is what the memorandum says. Lordship.
Okay, what is FR?
Fundamental.
What is that? What it says? What it says? Just FR? FR?
Yes, Lordship.
27?
16. 16, close to 16.
What it says?
Lordship, in the book I have, that is 16 is not there, Lordship. But 12, close 12, 5 is mentioned here, Lordship.
No, here actually in the notification it is 16.
Yes.
27, 16. So from where 16 comes if it is not there in the FR?
I think that
the edition maybe.
New publication, Lordship.
Just let's see FR 27.
May I, my lord?
Yes.
Just on this point, the service rules, our service rules are governed by our statutory rules.
No, Mr. Ejimami, I've understood the case. For my clarification, I just want what is 2716 for my knowledge.
Very well, Your Lordship.
Okay, anyhow, continue.
So, Lordship, more or less, submission is to that extent, Lordship. However, whether if it will help the case, Lordship, just
You know better than whether it will help your case. You know.
Lordship, this is
just with 1977.
Yes, for SCC.
1977 for SCC
345.
345. Just wait, okay. Yes, please. Paragraph 26.
26, I've highlighted it, Lordship.
Yes.
These instructions really fill up the yawning gaps in the provisions and are embedded in the conditions of service, Lordship. I'm talking, this is in support of the memorandum, Lordship.
So what you have to explain, these instructions really, maybe as per the facts of this case, maybe that was relevant.
Yes, facts are different, Lordship.
Yes. But in your case, actually, you have not made any statement that you have actually amended the service rules as per your notification. And that service rule is, that the service rule still survives.
So,
and I think that should be the final arbitrator, the service rules.
Yes, so what we state says is it lays the guideline for granting incentives. That is more than, and he is entitled under this 3 increments, that is a lump sum of 6,000. That is the submission of the state.
So what more?
So with that,
Any reply, Mr.
Your Lordship, what my learned friend is relying upon, I don't need to explain, but probably the government stands that the guidelines is filling up the spaces, available spaces. There are no spaces available as far as the service rules are concerned.
There is no gap in this case.
I think that is all, my lord.
Yes. Any more? Mr. A. Jimomi, the learned counsel for the petitioner, and Mr. Kiangami, the learned senior government advocate for the state respondents. Heard the parties in the light. Judgment reserved.
No.
Will pronounce the judgment.
Much obliged.